Hello, everybody. Thank you so much for joining us. My name is Cathy Naiser. I'm a realtor and I specialize in the probate process. And I have an attorney friend who is just amazing at the probate process. And so we thought we'd do a couple of interviews with him to really explain some of the different things that are important. Today's video is actually about wills, why it is so important to have a will. And so I'm really happy to have Mike Ezzell, attorney, here with us. Mike, can you tell us a little bit of about your background and how you came to become an estate planning attorney?
You bet. Thank you, Cathy, and thank you for having me here. My route to becoming an attorney specializing in probate and estates was a little bit circuitous. I actually started out many years ago as an engineer for Shell Oil. Shell put me through law school because they wanted a patent lawyer. So I was an engineer for a while with Shell Oil. Then I became a patent lawyer for Shell, and quickly discovered that patent law was just not my cup of tea. So I looked around private practice, moved from Houston to San Antonio, joined a law firm, and for the next 30 years or so, I spent my lawyer days in the courtroom trying lawsuits, product liability cases, trucking cases, various cases involving business disputes, that sort of thing.
So you were a litigation attorney.
Yeah, so I did a lot of trial work, a lot of courtroom work. And so then decided to go out on my own and found out very quickly that there was a need out there for people who needed wills, who needed help with estate management, and needed help navigating the probate courts in San Antonio and in Texas. And I just found I really liked it because it gave me a chance to really help people, people who were very much in need, either because they had a loved one who died and they needed to straighten out an estate, or because they were in need of their own estate planning documents. So to me, it was a natural transition because it gave me a chance to go from the hard-fought courtroom days into a practice where I was just really helping clients who showed a need.
Well, you and I have seen so many instances, Mike, where we think, oh my God, if they would have just had the will. I know in real estate so many times you don't have to have a will to sell real estate afterwards, but oh my God, the energy and time it saves on the loved ones who are left behind. So if you could just for a minute, for those who may not be familiar, explain what a will is and what its primary purpose is.
Well, a will is a document where an individual designates what is to happen with all of the assets, all of the property, everything accumulated by that individual during the individual's lifetime. So it's kind of one of the most important documents that an individual can draft, because it really involves a lifetime of possessions and what that individual wants to have done with those possessions. The will itself goes back, I think the first written will was something like 2500 BC. So it's a document with a long history, and of course even today recognize the will as it's certainly more than a contract. It's more of a covenant. The courts recognize it as a solemn document. It's one of the few documents that still courts require that the original document, the original signed document, even though it may have been signed 40, 50 years ago, be utilized to probate the estate of an individual. So it needs to be in a pristine condition. It needs to be unedited, signed, and original with all the witnesses. So it's just a document that is recognized as a very solemn document by the courts of the various states.
Well, you hear all these stories or on TV, you see people writing wills at the last minute and that kind of stuff. What are the essential components of a legally binding will?
Well, I'll speak of that from Texas, because of course I'm familiar with Texas and not so familiar with wills in various other states. And Texas has some very specific requirements. First of all, the individual has to be over 18 years old, 18 years of age. You can't, a minor can't sign a valid will, so it has to be over 18. The individual has to be of sound mind, and that's a very important requirement. It's one of the reasons why a will requires that two witnesses witness the signing of the will, because those two witnesses are vouching for the soundness of mind of the individual making the will, because the courts want to make sure that this individual's capacity is sound in being able to put down in writing what that individual wants done with a lifetime of property that has been accumulated. The will has to state the intent of the individual. It has to name someone else, generally a trusted person, who can discharge the responsibilities of the distribution of the estate assets and payment of the final debts of the individual. So those are the primary components. And then, of course, it has to be in writing, and it has to be signed and dated by the individual making the will.
Cool. So, you know, a lot of people think, I know I've met with so many and asked each time, do you have a will? And, you know, they think, I don't need one. We really don't have that much stuff. The house is community property, so it's both of ours. Why is it important for people to have wills?
Well, many reasons, but you've touched on one that's very important in the state of Texas, and that involves community property. So Texas has various ways to distribute property for individuals who die if they don't have a will. And some of those ways are going to have unintended consequences. People, you've touched on one of the issues concerning community property. They own a home, it's community property. So a lot of people believe, and I have run into this many times over the years, believe that if a husband and wife own a piece of property or own a home or own an account of some sort, if one of them dies, it automatically transfers to the other. But that unfortunately is not the case, because although the legal title may transfer, the ownership, the record ownership does not transfer until a legal process takes place. And so that's where a will comes in. It starts that legal process that allows an orderly transfer of property from an individual who died to individuals who survived that person.
So, okay, so I want to stop here because this is a big sticking point and a lot of misinformation or confusion out there. Two people are married, they own a house together, they bought it together, one of them dies. The other one doesn't just automatically get it?
No. In fact, if there is a second or third marriage and they don't have a will, there are some very severe consequences that take place involving stepchildren, children who may not be children of both the husband and wife. And there's a very good chance in that case where the surviving spouse loses completely the one half of community property owned by her spouse who is now deceased. And so that means
his heirs, his other heirs would get it.
His other heirs get it. His natural children under the state of Texas, under the laws of the state of Texas, his natural children would inherit his half of the community property. I'd say
even though they're married and they bought it together.
Even though they're married, they bought it together. Because and the principle is this: because when an individual, if an individual is married, when that individual dies, he is possessed or she is possessed of one half of the community, the other half goes to the surviving spouse, and then all of the separate property that person has accumulated during his or her lifetime, which may be from inheritance, it may be from lawsuits, various mechanisms where a piece of property becomes separate property, not community property. But if it's community property, the only property of the community that can be disposed of on behalf of an individual who dies is the community that was owned by that individual, because the other half of the community, of course, is owned by the surviving spouse. Does that make sense?
Yeah. So what are some of the other common misconception that people have about wills?
Well, of course, they think they're expensive, and they're not. In fact, I remind my clients that if you really put in perspective some of the other documents that you sign on an annual basis, or some of the other financial transactions you're involved in on an annual basis, the cost is very minimal compared to what you get from having the will and what certainty it places in one's life, because the consequences of not having a will mean that your property may very well not go where you thought it was going to go.
Any other misconceptions that are out there?
Yeah, a lot of people think that wills are self-executing. In other words, they think that, well, I'm going to sign this document. And by signing this document, all of the things that I put in the document are just going to automatically happen. And there does not have to be any further procedure to implement what I put in the will. And of course, that is not correct. And that's where a probate court comes in, because a will needs to be probated before a probate judge can appoint the surviving individual who can take the responsibilities of the deceased person and manage that estate and transfer that estate and pay off any estate debts and that sort of thing. So it has to go through that process. So there are, and I'm sure you've run into this, Cathy, where people think that, well, mom and dad have died. The house is sitting there. They left the house to us. So we're going to go in and we're going to remodel it, or we're going to sell it, or we're going to do this and that. Well, they really can't do that because they don't really have legal title to that property until it goes through the process of probate.
Okay. So, what happens if somebody passes away without a will?
If they pass away without a will, the state of Texas steps in. And Texas has, believe it or not, over 16 different mechanisms or 16 different ways to distribute the property of a deceased individual. Of course, the most common is it would go, if you've only been married one time and you have no children, then it would go to your surviving spouse. But then it starts getting complicated if there are children involved, or if there are stepchildren involved, or if the parents are still alive. There are all kinds of different ways that the state of Texas has of addressing distribution of property if an individual dies. And many times those ways are not in line with what the individual would have wanted.
Yeah, so basically, if you don't have a will, Texas is going to do it Texas's way.
Exactly.
No matter what you wanted or what anybody thinks they need.
No matter what you want or what they think they need. And people may have some misconceptions about what happens to that property. Let's say that there's an extended family, and one member of that family hasn't been heard from in 25 or 30 years. And I've had this actually happen not too long ago, where the people say, well, he's the black sheep of the family, and he's been gone for 30 years. He's not entitled to anything. Well, if he is a blood relationship, the state of Texas says he's just as entitled as are the people who are the proponents of an estate administration.
Yeah, I found that out recently, and I had a client call me. They actually went through the probate process. I don't think there was a will, and the somehow it was said all the heirs get a split of the house, right? And yet it didn't name the heirs. And there was one that they had no idea where that person was. Nobody had heard from them, which meant that they couldn't sell the house until they got in touch with that person and that person agreed. Yes. So, I said, start going to social media. Go on social media to anybody that might have known that person and ask where they are, that they just inherited, a portion of a property, and you're trying to reach them, and elicit other people on social media to help you find them. Because until you find them, you can't do anything with that property.
Exactly.
Am I right there?
You are exactly right. And you also raised another good point, and that is the cost. The cost of probating an estate, if there's no will, is significantly higher, sometimes 2 or 3 or 4 times higher than the cost of probating a will. Probating a will in Texas is a very straightforward, very inexpensive process. But probating an estate without a will gets expensive, and you've touched on one area that can get very expensive, and I've had to do this numerous times, is hire a private investigator to go out and find an individual that that from talking with relatives is in existence, either he or she or their children would be in existence. And of course, the children would inherit the individual's estate rights. So that costs a lot of money. In addition, if there's no will, the probate judge is required under state law to hire what's called an attorney ad litem. And that attorney is hired by the judge, has nothing to do with the attorney who's trying to get the estate probated. And the sole purpose of having that attorney, and that of course comes out of the estate assets to pay for that attorney. The Bexar County's not going to pay for that.
Right.
So that attorney is paid out of the estate, and that attorney's sole job is to find out if there are any unknown heirs. So the attorney has to do what you're talking about: go to social media, go to ancestry.com, hire a private investigator if necessary to find out if there are any unknown heirs out there who are entitled to inherit in this estate that is not part of a will.
Yeah, I know. We deal in real estate with affidavits of heirship sometimes for people who have not do not have a will. The problems we run into are, let's say there are several surviving children, and one of them actually died. Another child died, but they had children.
Yes.
Now you have to do an affidavit on the original person, maybe both parents or whatever, if both died without a will. And then you have to go to the one who died and do an affidavit of heirship on him to see the heirs. You have to get all that figured out to decide who all the heirs are before anything can be done with that property. And
yes.
So in that particular kind of sense, because that's something that could easily happen, right? Somebody died and somebody else had passed away. How would that have been solved or lessened the difficulty if they would have just had a will?
Well, a will is based strictly on what that individual wants to happen with his property. So the individual can say, I want to go all to my wife, I want to go all to my husband, I want to go to my children or grandchildren, I want to go to my friend who took care of me for the last 25 years. Or they may say, I want to go to a church or the SPCA or some other charity. The nice thing about a will is the individual can decide how that person wants to have his property or her property distributed, having nothing to do with family relationships. And generally, they are family relationships that come into play, but they don't have to be. And so an individual can override all of that and decide something completely different to be done with the property.
So when should somebody get a will, and what are the steps of doing that?
Well, yeah, interesting. When I looked over some information on that issue, generally, if a person has accumulated any significant property, any significant asset, they should have a will. If they get married, they should have a will. If they get divorced, that will probably needs to be revised. If they add additional children to their family, the will needs to be revised. If the will left estate assets to their parents or their brothers and sisters, and those people have passed on, then they need to revise a will or have a will. So a variety of reasons for having a will. And the nice thing about a will is it's kind of a living document. So the will can be drafted to consider lots of eventualities, some more likely than others, but the will can give alternatives for those eventualities.
So you can update it throughout your life, as you need.
It can be updated throughout one's life, but at the same time, if it's drafted properly, it can be made to endure a lot of changes that can take place as long as the individual is comfortable with the alternatives set forth in the will to address those changes that might happen.
Yeah, so getting a will at Office Max and getting it notarized probably isn't going to be drafted well enough to do what you're talking about.
No. In
That's
fact,
what I hear a lot of people talking about. Just go get a will online.
I have had to probate wills that came from Office Max and some of the online sources. And the problem is I tell clients it's kind of buyer beware, because whatever they get may or may not meet Texas law. And if it doesn't meet Texas law, then it is just going to add to the cost of probating that estate. And that is just going to just be more expense added on to administering someone's estate.
So what's the difference between a will and a trust? And do people need both? What are some big picture ideas there? I know that's probably a whole video in itself, but
it probably is, and there are a will can actually establish a trust. In fact, I've prepared wills where within the will I either have what's called a spendthrift trust, and I'll talk to you a little bit about that. A special needs trust where there's an individual who has special needs, or a children's trust or a minor trust. So the will can actually set that up within the will, and what it establishes is that if the beneficiaries are in a certain category at the time that this person who makes the will dies, then one of those trusts may come into play to place the assets in the name of a trustee, and the trustee administers those assets on behalf of and for the benefit of the beneficiary. So, but there are also trusts that, and that's called a testamentary trust. There's also a trust called an inter vivos trust, which is a during your lifetime trust, essentially. And a lot of people have those for administering estate assets while they're alive. And the trust may distribute either real estate or financial assets or a combination of both in a way that the individual wants to set up. And I've handled those. There's not quite as much need for those in Texas as there is in some other states, because one of the reasons people do the inter vivos trust is they believe that it's going to lessen the cost of probate, which probably overall in Texas is not true, because generally it's going to cost about as much to set up the inter vivos trust as it would to probate a will in Texas.
really? Mm. So what advice would you give someone who's hesitant about creating a will?
Well, what I like to do first is talk with the client about what assets they have, what family they have, what they would like to have done with those assets. And people have some very definite ideas, and you could tell when a client walks in my door, they have some real thought out and thoughtful ideas about what they want done with their property. So it kind of goes back to one of the things we talked about at the beginning of this conversation, and that is that people consider distribution of their assets to be a very solemn task, and they want it done properly. And so we go through those issues. What is the property? What do they want done with the property? Do they want to provide for a specific individual or a specific group of individuals or a charity? What is it that they want to do, and then start narrowing that down into drafting a document that meets those needs.
Okay. Yeah, and having just kind of gone through that with a friend, you could do a will emergency in a hospital or something like that really fast, probably with hospital staff. But to do the kind of work that you're talking about takes just a little bit of time. It's not going to happen in a week. You have to meet and break things down and review documents and make sure it's right and all that. So there's a time factor in there. Would you agree?
Yes, I would. It takes more than a few minutes. It's not just a matter of filling out a form.
Yeah. So, Mike, how can people get in touch with you if they have more questions? I know you do full estate packages, which include wills and powers of attorney and, information of what to do on deaths and things like that. So how would somebody get in touch with you to work up with any of those?
I appreciate that, Kathy. I'm going to screen share because I have a screen that gives my website my telephone, excuse me, my email address, my telephone number.
Okay.
And that's what I would ask is they can either email me at this email address or my telephone. So if I do a screen share here, I think it's going to work. Let's see.
It should.
How's that?
I'm seeing us. There you go. Let that just stay there for a minute, and
Okay.
I'll send that on a little bit longer too on the video as we do. Any final words, Mike, why people are looking at this about getting a will and the importance of making sure your loved ones have a will?
I think the only final word would be it's very, very important to have a will, because I have had so many situations over the years where where a person dies, doesn't have a will, and the unexpected happens, and it leads to heartache, it leads to family squabbles, it leads to all kinds of things that could have been avoided if the will had been in place.
Awesome. Well, thanks again. Again, this is Cathy Naiser. I'm a realtor and work with a lot of people working with probate and estate sales. And of course, we have Mike Ezzell, attorney, who now currently does a lot of estate planning and working with people to really help things move smoothly during their life and afterwards. So thank you so much, Mike, for being here and for sharing your information with us.
And thank you very much, Cathy. I really appreciate it.